Thank you very much. And what I'm going to say follows on, I think, in some ways quite nicely from what's been said. And in particular, I want to pick up the point that was made at the end there about the kind of historical legacy of the way that homicide is structured. So I'm going to say something about that. And I want to raise, particularly kind of focus on raising questions about how we would think about structuring homicide in order, and perhaps more controversially, to suggest that we can, although we tend to think of structuring homicide in terms of mens rea, that there's actually, in the Scottish legal tradition, a different kind of approach there, which focuses on the actus reus, and the other ways of thinking about structuring the law of homicide. So pulling away from a focus solely on the mens rea. Okay, so I can go through this quite quickly because a lot of this has already been covered, I think, in the introduction. Our standard view is that there's two categories of criminal homicide: murder and culpable homicide. The actus reus is always the same. This is what we teach our students. This is what, it's reflected in the definitions from MacDonald and his practical treatise, and reproduced by Lord Roger in Drury: a willful act causing the destruction of life. And we try and distinguish on the grounds of mens rea. So we have, broadly speaking, a picture of ascending seriousness through reckless killings up to intentional killings. And what we're trying to do is to get the most serious killings into the category of murder and distinguish the less serious killings, put them into the category of culpable homicide. But we're trying to do this on the grounds of mens rea. That's our standard view. And of course, there's problems with it, and some of these problems are already pointed out in the introduction. The problems are that there's the persistence of many forms of constructive liability. We see that most recently in McAngus and Kane, the case involving the unlawful act of culpable homicide. It's not clear, this is the second point, it's not clear how voluntary culpable homicide fits into this picture. So this is the problem that Lord Roger was addressing in Drury. When we're dealing with provocation, how is it that an intentional killing gets treated as culpable homicide? And the problems that creates for thinking about the structure. Of course, although it's just been said that this is not falling within the scope of this review, there are other forms of homicide, and these reflect the fact that there are other ways of killing which are regarded as culpable, but which are not. The fact that we don't seek to fit them into the structure of the law of homicide is not just a matter of historical accident. The fact that some are statutory and some are not. It's actually something that is problematic about the structure of our law of homicide that means that we don't think of these as easily fitting within that structure. And I think if we were serious about having a comprehensive law of homicide, we would be thinking about ways that these could fit inside the structure. And then there's finally the point at the bottom. And this is a quote from an article by an American scholar called Giora Binder. On the final slide, there's some references so that if anybody's interested in following these up, they can look at them. And Binder says, or makes comments, that most homicide does not result from a conscious decision to kill, and this reflects what Sarah's just been saying. Moreover, the fatal conduct we judge most antisocial is not necessarily the conduct committed with the most deliberation. That's saying that a lot of the kind of antisocial killings are not killings committed with deliberation, with intent, and therefore that this underlines the difficulty that we have in the structure of the law of homicide, trying to capture the important distinctions in terms of mens rea alone. So the question is, if we want to put the most serious killings into the category of murder, can this structure that we have accommodate it? And of course, I would also put in the proviso that what we might think of as being the most serious killings might change over time as well. It's not an absolute, given category. That if you look at this over a longer historical span of time, you can see that our attitudes towards certain types of killings change over time as well. And this is most obviously reflected, for example, in attitudes towards domestic violence, domestic abuse, and the kinds of killings, or killings certainly involving sex or sexual abuse nowadays. So, what I want to do is to take you back a little bit, so let's look at some historical perspectives. So, going back, this is historically, so that's looking from the 17th or 18th century onwards, murder was defined narrowly as forethought felony, reflected similar to the English category of malice aforethought, the idea of there being something planned. In 1661, there was an act of the Scottish Parliament that legislated that casual homicides and homicide and self-defense should not be capital. So originally all murder was capital, but the 1661 Act ruled that that's accidental killings, homicides and self-defense were not capital, but could be punished by arbitrary pains. So that it was still punishable, but not capitally punishable. And this also reflects the point about the impact of the death penalty over time. What did forethought felony mean, or forethought felony? It meant that certain kinds of violent killing were presumptive evidence of murder. So if we look back at the case law, we can see that where weapons were used, and this is where in a period where people were habitually carrying swords or daggers and so on, where weapons were used, where there was evidence of mutual combat, for example, where someone was engaging in the commission of another felony, where there was no evidence of provocation. These were the kinds of categories that were treated as presumptive evidence of forethought felony, falling into that narrow category. Things that, so by extension, if there was evidence of provocation, if someone wasn't engaging in the commission of another felony, many of the kinds of brawls that are kind of commonplace now would not have been regarded as forethought felony, would not have been regarded as murder, they would just be regarded as part of the incidents of everyday life. The focus then was on violent acts, the killing, all right, and on the antisocial motives, the dole. And the dole was presumptive, it was read off the violent acts. But what's important about this is the idea of killing. So it's not causing death, it's killing. And there's, I think, something significant about that. Culpable homicide was late to arrive in Scots law. Following 1661, some of the killings that were the casual homicides, some excessive self-defense were regarded as culpable, and this is the origin, if you like, of the category of culpable homicide in Scots law. Later on, during the course of the 18th century, provocation emerged as the principal category of culpable homicide. So the presumption was, if there was a violent act, if there was the violent killing, that it would be regarded as murder, unless the case could be made that there were reasons for excluding it from the category of murder, where there was provocation, where the 1661 Act was going to apply. And Hume, so the quote there from Hume's commentary, punishment in these cases of early culpable homicide could be according to the quality of the fault. So this was an innovation in Scots law over the course primarily of the 18th century. The key development that came over the course of the 19th century, and what happened in the 19th century was the rise of culpable homicide. Now, culpable homicide previously had been regarded as a residual category. It wasn't defined, it was cases that were not murder but that were in some way culpable. The first prosecution for culpable homicide in its own right was in 1781. That's the first one I've been able to find. Okay? By about 1820, they were becoming more common. By the end of the 19th century, I checked the criminal judicial statistics for about 1896 before I came down today. By then, we were looking at the number of prosecutions for culpable homicide being more than twice as many as the number of prosecutions for murder. So around about 60 or 70 for culpable homicide, 20 or 30 for murder in 1896. So culpable homicide becomes numerically the most numerous category. It's prosecuting different kinds of acts because it brings in many more of the kind of killings were happening in slightly different circumstances, and that might be situations where death was being caused. So there were cases, I mentioned the case here of Peyton McNabb. This was a death that was caused as a result of a railway accident. There were deaths caused by shopkeepers selling tainted food, or pharmacists selling drugs that hadn't been properly mixed or labelled as poisons, as well as brawls and so on. What culpable homicide required then was a proof of an intention to injury or a knowledge that another was exposed to risk. Okay, so it's becoming more recognisably the modern category of culpable homicide. But what's key here is that culpable homicide becomes the model for the law of homicide as a whole. So instead of the traditional model of killing with exclusions, right, we have the model of causing death, and then graduating that on the mens rea. Now that reflected many different changes. It reflected in terms of punishment the fact that the introduction of prisons for around about 1800 meant that more graduated punishments were available. So it's possible that the choices facing juries were not only capital punishment or acquittal, it meant that you could measure the punishment to the degree of fault. So the law of homicide was changing to reflect that. So Lord Young, in this case of Marshall in 1897, was saying all unlawful killing or destroying the life of a human being is culpable homicide, but the term murder is technically applied to that culpable homicide which is done maliciously. So that's the reversal that I'm talking about. Culpable homicide becomes the principal category. The structure of culpable homicide, the way we think about culpable homicide as causing death with culpably recklessness or exposing another to risk, becomes the model. Murder becomes a particular category of that. And then the category of murder changes as well. We then start talking about intention or wicked recklessness, as in MacDonald's classic definition. This system was established by the end of the 19th century. It was the system we carried through most of the 20th century. It was defended, Gerald mentioned a moment ago, the Royal Commission on Capital Punishment in 1950. In his evidence to the Royal Commission, Lord Cooper defended, in similar terms to Lord Emsley, in fact, keep your hands off our law of homicide. That's fine. He defended on the grounds that it was flexible, which it certainly was. And the flexibility consisted in the fact that the Crown could, and often did, charge culpable homicide, and could be sure of getting conviction for culpable homicide, where it would be potentially harder to get a conviction for murder. So they used the two categories. He defended also on the grounds that it was lenient, all right? And the leniency for him meant that Scotland was executing fewer people than England was. The question is it still lenient? So these are some figures which I've been given by Dirk van Zyl-Smit of the University of Nottingham about the mandatory life sentence, the use of the mandatory life sentence in Scotland. I apologize, it's perhaps rather small to see. The key line is this one. These are the numbers of life sentence prisoners. And this is the Scottish figure for life sentence prisoners. So basically in Scotland, we have around about 1,000, well, not round about, precisely 1,038, this is from 2016, 1,038 prisoners sentenced with life sentences. That is 16.6% of the prison population. The prison population is round about 7,800. Okay. That is the highest in Europe. So these are up above this, and these will be circulated afterwards. Above this, these are the figures for other countries in Europe. England and Wales 9.9, France 0.9, Germany 3.7%. Okay, so we have it dramatically higher than elsewhere. India is dramatically higher than Scotland, but Scotland is higher than South Africa and the United States. We have more life sentence prisoners than anywhere else in Europe. And this graph here on the right side shows the increase from 2000 to 2016 in the numbers of life sentence prisoners. So we're going from around about 600 in 2000 up to the current figure of over 1,000 in 2016. So it can increase, a dramatic increase there.
Sorry, just to interrupt you. Are those all mandatory life sentences or some discretionary life?
There's some discretionary life. It's mainly mandatory life sentence, as I understand. I can check that with.
I think the number of discretionary life sentences imposed now is absolutely minimal in Scotland because of orders for lifelong restriction.
Right.
Yeah.
Sorry.
Okay. No, that's fine. So why is it happening? There's three reasons which are suggested, and again, I'm thankful to Dirk for writing this. So non-parole periods imposed by the courts are getting longer. So the average non-parole period has risen from 13.8 years in 2004 to 18 years in 2013. There's a low number of releases of life sentence prisoners by the parole board. In 2015-16, only 44 of 336 cases for parole board were released. 195 rejected and 144 postponed, 13 withdrawn. And then thirdly, there's a long-term growth in the number of life sentence prisoners returned to prison annually. So that was only 10 in 2002 to 3. An extra zero in that thing, I'm afraid. But it's gone up to 89 in 2016-17. So the question this raises is, are we in our category of murder, which has the mandatory life sentence, is this being reserved for the worst of the worst? If we want murder to be the most serious killings, is that really the case? And I think this really follows on nicely from what Sarah was saying earlier. Are we doing that? And these figures are quite shocking to me about when you see it like that we're imprisoning many more. And suggest that there's something is going wrong, that we're putting more cases into the category of murder than we should be putting into the category of murder. So implications. So the big question, I think, is the model of culpably causing death still the appropriate model? Is that really doing what we wanted to do in the sense of getting the most serious killings into the category of murder? But in going forward from this, what I want to encourage the Law Commission to think about is to explore looking at the actus reus of the crime and not just at the mens rea. I think the way, and again, I think this follows very, very nicely from what Sarah was saying earlier. Murders are not premeditated. They're happening in very different kind of situations. So a category of murder that is focused primarily on the intention to kill, understood historically in that sense, planned or premeditated, is perhaps not going to be very effective here. But we do have resources. We can think about this more broadly, but we have resources also in the sense of the Scottish tradition in dealing with homicide. If we think about different the distinction between killing and causing the destruction of life. Killing is a certain type of act. Killing is different from causing the destruction of life. And so thinking about what killing might mean, and whether we could use thinking about the category of killing as a way of trying to make some distinctions might be a way forward. There's also an example here from the German Criminal Code which distinguishes between different types of killing or killings with different kinds of motives. So that the provision in section 211, any person who kills a person for pleasure, for sexual gratification, out of greed, or otherwise base motives by stealth or cruelly, or by means that pose a danger to the public, or in order to facilitate or cover up another offence. And that is the higher degree of murder in Germany that carries a mandatory life sentence in Germany. So it's the definition of murder here is much more textured than an intent to kill or a wicked intent to kill, because it's referring to contextual factors, it's referring to the kinds of motives. And this might be a useful way of thinking about drawing some important distinctions. And I was just making notes while Sarah was talking, so you might think about factors such as, is it happening in private or in public? Is it domestic? Is there a context where there's domestic abuse? Is it the man or the woman who's doing the killing in the context of private domestic abuse? I have to mention this, is it a serial killer? We know they're not very common, but that would be the kind of thing that you regard But also that you might say, well, certain kinds of alcohol or drug-fueled rage would be regarded as, could be falling into that category of killing. There's ways, I think, at least of exploring or thinking about the kinds of distinctions that might be made here. And I put a little note in at the bottom as well. We might distinguish, and I'm not sure whether the words I've used here, the formulation, would exactly work. An act causing death or conduct resulting in death, to think about different types of culpable homicide. So that where somebody fails to act, and that causes death, that the conduct causing death, that might be regarded as different from an act resulting in death. That's to say, somebody who is involved in a street fight and stabs, a single stab wound to the victim. You say that that's, and so there might be degrees of culpable homicide that we would want to try and reflect. But what the point I'm trying to make is thinking about the actus reus offers opportunities that we tend not to think about in this context. Secondly, and I'll finish very shortly, it may not be within the scope of the review to remove or address the mandatory life sentence, but what could be done certainly is to limit the effect of the mandatory life sentence by thinking about narrowing the category of murder. And here, I flag up Jeremy's talk, has already been flagged up. The English Law Commission proposed introducing 2 degrees of murder for precisely this kind of reason, to try and think about ways of limiting the impact of the mandatory life sentence. I think that's something that we should think about. And then finally, this is the point about should we be thinking in terms of a ladder or a grid? And the terminology for ladder is again from the English Law Commission and gave rise to quite a lot of discussion. But the ladder typically is what we have been thinking of, the kind of model that we've had, where we're thinking of the act being always the same and thinking about ascending degrees of seriousness in terms of mens rea. That's the ladder. You go up the rungs of the ladder, it gets more serious. Okay? But the grid suggests that we might think about different categories of killing that are not necessarily differentiated solely on the basis of mens rea. And that are, it's a different way of trying to map what our views of culpable, most serious killings are that are sitting in a different kind of relationship to each other. And I think, again, that's something to think about going forward. But this is raising the questions, and I don't pretend to have answers to those. Okay, so I'll just finish there. These are, as I say, the references, things I referred to, and they'll be circulated later on.
Thank you very much for that. That's great.